Greetings. Welcome to Talk Law with Monare. My name is Monare and I'm your host. This is our second episode in the labor law series. In the first episode, we talked about the concept of labor law. We described labor law and its founding principles. So today, we'll be discussing the historical development of South African labor law, of labor law in South Africa. So, the historical development of labor law in South Africa cannot be discussed without the discussion of the socio and political history of the country. However, we will not be holding a history lesson into the socio-political demographics of South Africa. So, the labor law system in South Africa started with, it emanates from the discovery of diamonds and golds and other minerals in South Africa. So, which happened in the 19th century. Before then, one can say South Africa was largely a rural and agrarian society. So, an agrarian society is one whose economy is based on producing and maintaining crops and farmland. So an agrarian society is one which is dependent on agriculture. And so it was only until 1922, after the Rand Revolt, that South Africa had its piece of labor legislation passed, which was called the Industrial Conciliation Act of 1924. So the act laid the foundations for the South African labor law system, and some of its elements, some of the elements of the Industrial Conciliation Act of 1924 can still be found in the modern day Labor Relations Act of 1995. So through the Industrial Conciliation Act, what was established is the industrial councils and bargaining forums. So the notable thing about this act, however, it was its unhidden racial discrimination. So why am I saying racial discrimination? Well, the main object or the main objective of the Industrial Conciliation Act was to protect and to promote the interest of white workers at the expense or at the essential exclusion of black workers, who obviously did not enjoy the benefits of industrial councils and bargaining forums. So, because I noted the Rand Revolt that took place when white workers wanted to be treated differently, wanted their interests to be more protected and more advanced than those of their black counterparts. So the government at the time took heed to these calls from white workers and indeed passed a legislation that was exclusive to white workers in the mines. So it was only until the 1950s when black workers' interests were taken into consideration in the formation of works committees and liaison committees. So this move, the move to now take into consideration the interests of black workers, was propelled by the fact that black workers at the time in the 1950s had started to organize themselves into trade unions. So because they realized that there was no piece of legislation which was protecting and advancing their interests, black workers then saw it fit to organize themselves and form what we now know as trade unions. So the trade unions, they continued with their growth despite the strategic measures to undermine their growth. So when black workers started to organize themselves into trade unions, the legislature then started to afford a bit of benefits to black workers by saying, well, now you guys can have access to you can now have access to industrial work committees or works committees and liaison committees. So that decision from the legislators' point of view was to halt the growth of trade unions. So, however, that did not achieve its purpose because the trade unions kept on growing, and the more they grew is then what led to conflicts in the workplaces, because now black workers had trade unions to represent them, while white workers still had a piece of legislation that was advancing their interests. So now, with those conflicts then is what led to a commission of inquiry, which was called Vietnam Commission of Inquiry, which was held in 1970. And the main object thereof was to look into these various conflicts in the workplaces, which came as a result of black workers organizing themselves and white workers still having basically the disputes which arose as a result of the growth of trade unions. So the main recommendations of this from this commission of inquiry is what led to the passing of legislation which gave trade union representatives of black employees access to institutions established by labor legislation, which is the industrial councils and bargaining forums. So, because these unions, the various unions in various industries, because they were small, they were only representing a number of workers in certain separate workplaces. So basically, there were no trade unions which were so large that they were able to bargain at industrial level. For instance, in the beverage industry, there were no unions which were large enough to bargain in the beverage industry at large. So as a result of their size, the unions could only bargain at what we call plant level bargaining system. So plant level bargaining system means that as a result of a trade union only being able to recruit members, let's say for instance, we've already used the example of beverage industry. So let's say the union only managed to recruit members at Coca-Cola. So because the union only had members at Coca-Cola, which we will classify as a plant, the union then only had powers to represent employees of Coca-Cola. So that is only at that plant level. So now that's the only focus for the union at the time. At plant level, at Coca-Cola, they could only represent Coca-Cola employees. So now what that means is this: one, the union would recruit employees of Coca-Cola, and once it feels like it has enough members, it has recruited enough employees of Coca-Cola at that particular plant level, it will then decide to go to the employee who being Coca-Cola company and say to Coca-Cola, look, we have recruited, or we've managed to recruit enough of your employees into our union. So we demand recognition as the bargaining as a bargaining agent for those particular employees. Then once Coca-Cola agrees to recognize the union, then the union and the employee, being Coca-Cola, would enter into what we call a recognition agreement. So the recognition agreement is an agreement which acknowledges and recognizes the trade union as being the representative of the employees for bargaining purposes. Thirdly, the recognition agreement would then um, in addition to recognizing the trade union as the bargaining or as the collective bargaining agent, they would also grant the union what we now know as organizational rights. So to understand the type of organizational rights that a union would need or would demand or would be entitled to with regards to a particular workplace, one can go to chapter 3 of the Labor Relations Act, because the current Labor Relations Act in chapter 3, in sections 4 to section 26, that's when the organizational rights of a trade union are described, and which type, and all the activities which relate to a trade union. So the recognition agreement would further outline the rules and procedures for future bargaining in terms of dealing with future labor disputes. So the recognition agreement will state, for instance, that when there is a dispute with regards to wages, this is how the parties of interest would then approach the matter. There must be maybe a consultation between the union and the employees, between the union and the employers. There will be wage negotiations, or there will be wage increment negotiations which have to take place before a union can go on a strike. So now, with those development where this small or these black unions now have enough bargaining power at plant level. So let's say trade union A has managed to enter into a recognition agreement with Coca-Cola. And then you have trade union B, which has managed to enter into a recognition agreement with Pepsi. You have trade union C, which has managed to enter into a recognition agreement with, let's say, South African breweries. So now you have three unions in the beverage industry. Trade union A, B, and C, representing employees in three different plants. So with their growth, these are three unions. With the growth of these three unions, what then happened is that because at this time they are only bargaining at plant level. So now they wanted to grow and expand their bargaining power or their bargaining scope to industry level. So what they did, these small trade unions, they came together to form, let's say, a federation. For instance, you would look at, let's say, maybe COSATU, for instance, or let's not use COSATU as an example. Let's say trade union A, B, and C, which are representing employees in different plants in the beverage industry, they come together to form trade union F. Trade union F will now be bargaining at industrial level. So they then, these small trade unions started to consolidate their power in the 1980s, when they had now realized that, well, at plant level we have enough power, we can now try to bargain at industrial level. So effectively, what that meant is that the minimum terms and conditions of employment negotiated by trade union F at industry level, whatever collective agreement is reached at that level, it applies across the whole industry. Because when you look at trade union A, if trade union A representing employees of Coca-Cola entered into a collective agreement with Coca-Cola, that particular collective agreement was only applicable at plant level, meaning it's only applicable to employees of Coca-Cola. It doesn't affect employees of Pepsi. Trade union B would enter into an agreement which applies to employees of Pepsi, and trade union C for employees of South African breweries. So now, at bargaining at industrial level, a collective agreement at industrial level means that trade union F entering into an agreement with those various employees, being Coca-Cola, Pepsi, and South African breweries and others. The agreement, that is collective agreement at industrial level, means that it's an agreement which applies across the whole industry. So there won't be a need for special conditions and terms or a wage increment agreement for employees of Coca-Cola, employees of Pepsi, employees of of South African breweries. So a wage increment agreement will be applicable across the whole beverage industry. So now, that also included issues such as pension, issues such as provident funds. So, for instance, if at industrial level or at industry level, the collective agreement was that with regards to pension fund, the employer will contribute 5% towards a pension fund. That means all employers in that particular industry will make a contribution of 5% towards its employees' pension fund. It does not mean separately Coca-Cola, Pepsi, or South African Brewers. It's an agreement which applies across the table. So that is a system that is still being followed up to modern day labor market in South Africa. It's a system which still applies today. One can look at the recent public wage dispute, which took months and months. So now, when an agreement was reached in the public wage dispute, the agreement that was reached between the PSA and the government was that, it applies across all public service. It's not an agreement which applies only to employees working for the Department of Correctional Service or employees working for the Department of Education. It's an agreement which applies across the industry, being public service. So one other effect, or rather outcome, of the Vienna Commission is that it led to the formation of the Industrial Court. So the Industrial Court's primary objective was to guard the conduct of employers, employees, and trade unions, so that, and it measured the conduct against concepts or the principles of unfair labor practice. So the Industrial Court then developed an approach which was based on the principle of fairness in order to fulfill its mandate. So we'll briefly touch on the concept of fairness a bit later. So the Industrial Court then continued to fulfill its mandate excellently, and this bold statement is made due to the fact that it was the Industrial Court that gave, or rather passed, provisions with regards to strikes and how strikes could possibly affect employees. So the court said, rather established legislative principles which also touched on issues of victimizing employees during strikes, because we know that historically employees were often fired or dismissed for taking part in a strike. But now the legislation is such that you can't just fire someone for taking part in a strike, even if they destroyed property or they didn't get permission or they absconded for them to partake in a strike. It's not a simple matter as you were in a strike, you didn't come to work, therefore you are dismissed. There are still fairness principles to take into account, because even the Labor Relations Act, as part of the organizational rights given to trade unions, employees have a right of association, rather they have a freedom of association. If they want to join a trade union and partake in trade union activities, then they can do that without being victimized for any part that they play in in trade union activities. So trade unionism and collective bargaining, it kept growing in South Africa in particular, because as we said, the conflicts developed in the mines, in the diamond mines, in the gold fields, where there were black workers and white workers. So that is the private sector. So any piece of legislation, any labor law development up until the 1990s was taking place in the private sector, in more so in the mining industry. So now it was only until the early 1990s in South Africa that the legislators' focus then started to shift from the private sector to the public sector, because now there was also a growth in the public sector. You now had nurses, you now had teachers, you now had doctors, you now had workers in the agricultural industry. So there was now a need for laws which would then govern the public sector. And in 1993, the legislature passed the Education Labour Relations Act. They also passed the Public Service Labour Relations Act, and also they passed the Agricultural Labour Act. So these acts they formed the foundations of labor law for the public sector, and they kept growing, because in 1995 we then came into, or rather that's when the Labour Relations Act that we apply today, that's when it came into effect. We now have legislation such as the Employment Equity Act, because remember when we started our discussion with regards to the Industrial Conciliation Act of 1924, we mentioned that it was an act which was rooted in racial discrimination. So now, with the coming into effect of Employment Equity Act, that then meant that we now had a piece of legislation that recognizes the racial injustices of South Africa, or South African in the South African history. So the act then have policies such as affirmative action. Affirmative action policy is one that primarily takes into account when you are dealing with job placements, job applicants, you are dealing with passing employment policy. It's one that takes into account previously disadvantaged communities, in particular Black Africans. So now it's a piece of legislation which one can almost say it's a mirror, but then it's basically it's an opposite of the Industrial Conciliation Act, because while the Industrial Conciliation Act was rooted in protecting and promoting the interests of white workers, the Employment Equity Act seeks to undo that and take into account that when you, for instance, when you have job applications before you need to take into account the fact that Black Africans were previously disadvantaged. They didn't have access to a certain skill set, skills training, some level of education, opportunities. Certain opportunities in the past were only reserved for their white counterparts. We also have legislations such as Educators Act, which one would say the foundation thereof was the Education Labour Relations Act. You have pieces of legislation like Compensation for Occupational Injuries Act. It's a number of them, and if you go back to our first episode, that's where we mentioned them in passing to say these are the type of labor legislations which have been passed in South Africa since 1994. which seek to always develop in line with the social and the socio-political developments of the country. So just as a brief description of what the principle of fairness, I know we mentioned in our previous episode. What the principle of fairness, for instance, let me give you an example. Because we know that in labor law, you not only deal with, let's say, the Labor Relations Act or the Basic Conditions of Employment Act, you also touch on the common law of contract, the principle of common law of contract, like freedom to contract, basically, which means that an employer and employee can enter into any agreement they deem fit. So now, let's say, for instance, an employee commits an act of misconduct, or maybe there's an act of incapacity, or due to operational requirements, you need to retrench some of your employees. So now, the conduct of the employer might have been lawful when it's measured against or when it's measured in terms of the common law of contract. The employer might have acted lawfully in terms of the contract of employment. However, just because it's lawful does not mean that it was fair. In fact, a lawful conduct could nevertheless be unfair. So you need to take into account the circumstances of the employee. For instance, an employee might have entered into a contract of employment based on probation, but then during analysis, it's established that in as much as the probation period has ended, the employer did not provide the employee with a reasonable evaluation, or the tools of trade which were provided to the employee were not enough for the employee to adequately display their skills or their capacity or their ability to fulfill or to carry out the duties. So when you do an analysis from a fairness perspective, you are able to establish that it's unfair to terminate the contract of employment or to dismiss the employee. So that was our second episode into the historical development. It's a long discussion which needs us to tap into the socio-political dynamics of South Africa. So that's, unfortunately, for the purposes of our discussions, we cannot dwell much into that. But in brief, that's the discussion. So thank you guys for watching, and please hit the subscribe button and also the notification button, so that as soon as we upload our content, you are able to access it and enjoy more fruitful discussions with us. Yes, thank you for watching. That was Talk Law with Monare. I'm Monare, your host, and remember, the law is for justice, the law is for reparations, and the law is for building. Thank you.